We will get started with the next case, Lichon v. Morse. Each of you has 20 minutes. Mr. Riley, I assume you will attempt to save some of that for rebuttal. You may begin.
Good morning, Your Honors. May it please the Court, Robert Riley on behalf of defendants Michael Morse and Michael J. Morse, PC. If I may, I would like to reserve 5 minutes of my time for rebuttal, and I recognize that I'm responsible for keeping track of that nice big clock in the left-hand corner. I'm also happy to waive the free fire zone. This is a case about the scope and enforceability of every arbitration agreement governing workplace claims in existence in Michigan. At its core, it really is a straightforward dispute over the meaning and application of a contract in which the Court of Appeals overlooked the plain and ordinary meaning of the parties' arbitration agreement. In doing so, the Court committed numerous errors to reach a conclusion that was admittedly based on two judges' preferred policy outcome. The Court should reverse that judgment and reinstate the Circuit Court's orders compelling arbitration of plaintiffs' claims for one simple reason. The Court of Appeals ignored the parties' agreement that requires arbitration of all disputes relating to plaintiffs' employment, including claims for termination, discrimination, violation of state or federal labor or employment laws, and tortious conduct proscribed by the firm's employment manual. To reach its erroneous conclusion, the Court of Appeals had to further ignore the substantive allegations in every single count of each of plaintiffs' complaints that alleges exactly those types of claims. Among those claims were accounts for workplace sexual harassment against the Morse law firm, claims that are beyond doubt arbitrable. The Court should reverse the Court of Appeals judgment.
I'll take you up on your invitation to interrupt you and go right to questioning, and we're going to do it one by one, Mr. Riley. So, Justice Markman, you get to go first again. You're winning.
Wow, this is a very special day for me. Thank you. Mr. Riley, thank you for being here. Do you have any concerns or reservations at all about the variety of common law tort claims that seem to constitute most of what's at issue here and their propriety for being heard in the arbitration process?
We certainly take those allegations seriously, but we don't believe there is a basis either through common law or the parties' agreement that would prohibit arbitration of those claims. So the specific counts in plaintiffs' complaints all relate directly to employment, and the complaints are replete with allegations that specifically tie those torts to plaintiffs' employment. In addition, the parties' employment manual, the Morse firm's employment manual, specifically lists certain tortious conduct that's prohibited in the workplace. Those are exactly the types of claims that, one, are subject to arbitration under the agreement, but also are exactly what plaintiffs alleged. So we don't believe that the simple fact that they allege certain torts would bar arbitration of those claims.
Thank you, counsel.
Whether plaintiffs' employment-related claims are covered by the arbitration agreement is informed by a three-part analysis. Is there an agreement?
Mr. Riley, I'm going to keep interrupting you and let me go through my colleagues, and then we'll get back to you if nobody has any questions, but they might. Justice Zara?
Questions, thank you.
Justice Viviano?
Yes, thank you. Counsel, I guess I have a question that's a little bit, it's about an issue that I'm not sure has received much attention, but it's been of interest, at least to me. And that is, should it matter to us? My understanding is your client in his individual capacity is not a signatory to the arbitration agreement. First of all, is that correct?
That is correct.
And how does that factor into the analysis? Or should it not?
We don't believe that fact precludes arbitration of the claims against Morse in his individual capacity for two reasons. First, it would not give full credit to the language of the MDRPA, which, quote, applies to all concerns you have over application of the firm's policies and procedures, including disagreements about the topics that I listed before. But it goes on to say that the procedure includes any claim against another employee of the firm for violation of the firm's policies. Mr. Morse is also an employee of his firm, so we believe that he is well within the arbitration clause. But also, we believe that excluding Morse in his individual capacity from the four corners of the arbitration agreement would do disservice to the court's 2016 decision in Alta Belli. That case considered whether the plaintiff's tort claims against individual principals of a law firm fell within the scope of the arbitration clause that mandated arbitration of any disputes between the firm and its former principals. And the court held that the claims against the principals of the firm are arbitrable just like the claims of the firm itself, even where those principals did not sign the arbitration agreement. Here, plaintiffs expressly recognized in their complaints that Morse is an employee, owner, and agent of the firm, and that's Lichon complaint paragraphs 32, 62, and 71, and Smits complaint paragraphs 4, 49, 57, and 75. And because acts of officers and agents of a corporation are really acts of the corporation themselves, the claim against Morse individually and against the firm are both subject to arbitration.
Okay, thank you, counsel.
Justice Bernstein?
Counsel, good morning and welcome to the court, and thank you for coming and joining us today. I have a few questions that I just want to go through, because the way I like to kind of approach these issues is I like to do it in a very pragmatic, more practical kind of basis. So the first question I would have for you is that ultimately your argument is that this, of course, should be subject to arbitration. Because the alleged incidents took place, during either at a Christmas party or with the receptionist at the office itself. And I guess my question would be, as I kind of am thinking about it and looking at the law and looking at the Court of Appeals opinion, is ultimately where I have a hard time with this, and if you could kind of help me with this, I would appreciate it, is that the situation that we're looking at, the allegations of the groping at the Christmas party and the other things that took place with the receptionist at the firm, where I'm confused is that I just don't see how, in a more practical way, how does that go to the role of the employer-employee relationship? And this is clearly behavior and conduct that would kind of go beyond that scope. And I guess my question would be is, if this court were to reverse the Court of Appeals opinion, if you were to commit any type of allegation or any type of conduct that was criminal in nature and it was at the workplace or at a workplace function, is it your contention that that too would then be subject to an arbitration agreement?
So we don't argue as a matter of course that all claims are always within every arbitration agreement. I don't think that this particular agreement contemplates that, and I don't think that would necessarily be a sound rule. But I think underlying your question is the notion that there has to be some link between an employment-related claim and whether it's subject to arbitration. And here, I think the best evidence of that are the plaintiff's complaints. And we have to take those complaints at face value. These cases were decided on a C7 motion to dismiss, so we have to, frankly, accept the allegations as true. And I'm not cherry-picking a few select paragraphs from plaintiff's complaint when I suggest that these complaints are replete with allegations that Morse was acting within the scope of his employment, that plaintiffs were acting as employees within the scope of their employment, and that defendants, the gravamen of plaintiffs' complaints is that defendants created a hostile working environment. Those are exactly the types of claims that are routinely subject to arbitration. And I would also point, because I believe there's an element of what your question gets at of foreseeability, or how you tie these alleged actions back to the workplace. The legislature has expressly recognized, unfortunately, that these types of situations arise in workplaces. And that's why it enacted the Elliott-Larsen Civil Rights Act, which expressly provides a remedy for plaintiffs who suffer from these types of actions. To be clear, the legislature recognized that discriminatory conduct that takes place in the workplace is actionable under Elliott-Larsen. It defines sexual assault and sexual harassment to include conduct or communication that has the purpose or effect of substantially interfering with an individual's employment, or where that conduct creates an intimidating, hostile, or offensive work environment. Lest there be any doubt, that's exactly what the plaintiffs in these cases pled. Lichon alleged that she was an employee and the defendants were employers within the meaning of Elliott Larson. That's paragraph 36. At paragraph 45, she alleged that the defendant's conduct substantially interfered with her employment. Paragraph 50, the defendant's conduct created an intimidating, hostile, or offensive work environment. That's exactly what's prohibited by the Elliott Larson Civil Rights Act, and Elliott Larson claims are routinely arbitrated as a matter of course, and Smits' allegations are nearly identical. I would also note that there's obviously the elephant in the room is the public policy surrounding arbitration and sexual assaults and the times that we live in. We don't dispute the seriousness of workplace sexual assault allegations. We don't dispute that plaintiffs are entitled to a forum in which to prosecute their rights. They absolutely deserve that. And we also don't dispute the importance of public policy or that it may weigh on the court's mind when considering these or the next 1,000 cases. But to the extent the court does consider public policy, we believe the court should defer to the public policy enacted by our legislature as opposed to two judges' determination of what our public policy ought to be. And historically, there are only two bases under Michigan law for challenging an arbitration agreement on the basis that it violates public policy. And that's one, that it unfairly truncates or denies legal rights or remedies that would be available absent the agreement. And here, there's no allegation that plaintiffs have any fewer rights or available remedies under arbitration than they do in a court of law. And second, you could challenge an agreement based on public policy where it essentially allows the courts to intermingle with the arbitrator and use courts as a resource for the arbitrator, like by issuing an advisory opinion or something like that. We don't have that situation here.
But so, counsel, I guess my concern would be, and I'm just asking you to kind of help me with it because I'm trying to just kind of do a balancing test as it kind of pertains to this. And I guess the thing that I'm trying to kind of grapple with is, let's just focus on the one complaint, which is I realize they're consolidated, but let's just focus on the Christmas party, because that's something I just kind of want to focus on as it pertains to this arbitration agreement and how to kind of move forward. And I recognize and I appreciate the fact that you're addressing the public policy component to that, because that seemed to be a kind of a major element as it pertained to the Court of Appeals decision. And I guess the concern I would have is that in this situation, we're looking at specific conduct that arose at the Christmas party. So this happens at the Christmas party, and I guess according to the allegation, there was some very concerning conduct as it pertained to that. The question I'm going to go back to is that what I'm trying to figure out is that if we were to reverse the Court of Appeals, what would ultimately a decision like that say? Would it say that, would there be, what protections, we're talking about the how to proceed this, but what protection would someone have if an action takes place at an event that's a corporate event? Would it be your contention that there wouldn't be any limitation onto individual conduct at a corporate event, and that all action and conduct at an event, and this was some pretty intense conduct according to the allegation, would that then ultimately be subject to arbitration? I mean, ultimately, I guess the way I would phrase it is, if you have a corporate event, would it be a situation where anything goes, and as long as it's at a corporate event, you could do anything and everything you want to an employee, and that would then be subject to arbitration, so long as it's at an event sponsored by the company?
I would not urge that a company party is a free-for-all for any of the type of conduct that's alleged in these cases or potentially any future case. What I would suggest is that the complaints that we have before the court specifically tie each of the allegations of assault or harassment to the employment relationship. And in this case, it happened to be at a Christmas party where, according to the complaints, the defendants were acting within the scope of their employment. So Could there be a case where a plaintiff alleges that some things took place that shouldn't have, that were outside the scope
How
of
is
the...
it what I'm trying to understand is, and I'm not trying to quibble with you, I'm just trying to understand. I'm just trying to grapple with the notion, how is it within the scope of the employment to, and I don't want to get into the allegations, I'm just trying to understand, how is that part of the scope of employment in terms of the conduct and behavior that took place at the party?
We're left with what plaintiffs have alleged took place. And these aren't my words, these are plaintiffs' words.
Right.
These actions all took place within the scope of employment. So is there a situation that would fall outside of that? Yes, I think it depends on how the plaintiff pleads their case. But all we have before the court today are 2 complaints that are replete with allegations that each of these specific events in both Lichon and Smits, whether at the Morse law firm or at the Christmas party, took place within the scope of employment. So I understand your point, Your Honor, and it's a good question, and there are certainly ways to plead a complaint in a future case that may not implicate the employment relationship. But that's not what we have before us today. Plaintiffs were the masters of their complaint. They chose to allege workplace-related allegations, employment-related allegations, claims for discrimination under Elliott-Larsen Civil Rights Act, which expressly prohibits workplace discrimination. We can't go beyond the words of the complaint. We're left with plaintiff's allegations, and those are workplace-related. So sure, a future case could turn out differently, but I'd have to see that complaint to give you a better answer of whether a certain allegation is outside the scope of employment.
Counsel, thank you very much.
Justice Clement?
No questions, thank you.
Justice Kavanaugh?
Yeah, I guess I'd like to hear your thoughts on, at the end of the day, we are asked in any case similar to this is to construe the language of the particular arbitration agreement and the claims brought by the plaintiff. And I guess, I think notice that you rely heavily on the proposition that we it's the policy of the state to encourage arbitration, and the I'm probably getting this wrong, the Ruyaker case of that, that it should be construed to anything that arguably falls within that. That to me seems at odds with our obligation to construe the language of a particular contract and the claims that are alleged under that. What is the role of this sort of policy of favoring arbitration in construing particular contract?
Your Honor, the arguably within standard that I think you're referring to in Ruyaker and numerous Court of Appeals cases, that's not an outlier. That was simply a product of this court's decision in the Kaliva-Norman-Dixon case, which relied on a U.S. Supreme Court case, the United Steelworkers of America, the Warrior and Gulf Navigation case. That's where that standard came from. Even if the arguably within standard didn't apply, and we simply consider the plain language as it exists now for everyone to read, I don't see any credible interpretation of plaintiff's allegations, which are for state civil rights violations, how those could fall outside of the scope of an agreement that says state civil rights claims must be arbitrated.
So the civil, I mean, I may not disagree with you, I think, on the civil rights claims or the harassment claims, but what about a claim of sexual assault?
Well, that's conduct that's prescribed by the firm's employment manual, and disputes over the firm's employment manual are also subject to arbitration. But I would also point to, and I believe it came from the Ruyaker decision, is that Michigan courts favor keeping all disputes arising out of the same set of facts in a single forum. We have a strong public policy in favor of arbitration, as you're aware, but if we dive into segregating arbitrable versus non-arbitrable claims into different forums, according to Ruyaker, we've lost the efficiencies and effectiveness of arbitration as a means of resolving disputes. So I don't believe that segregating tort claims from otherwise arbitrable claims would be appropriate.
Okay, and I just want to, you said in your opening that this is the importance of this case is every arbitration agreement in Michigan. And I'm just, that's not necessarily true. I mean, this particular arbitration agreement, which is specifically written to tie arbitrable claims to claims that are relative to your employment. That's not the case in a number of other cases across the country, or perhaps even across the state, regarding this issue of whether claims of sexual assault or harassment are included in arbitration agreements, because a number of those are actually worded much more broadly. I think it's arguably a harder question, but in this case, it's this particular agreement that ties the question to the phrase relative to your employment. Correct?
That's correct. And I hope I got this right in my introduction, but I believe I said that this case implicates every arbitration agreement governing workplace claims. I believe it does have implications beyond the workplace arena if the Court of Appeals is permitted to select out of the Elliott Larson Act a single group of protected individuals and elevate them above, different races or religions or national origins, and those claims could be arbitrated. Then I think it's inappropriate for the court to have elevated one category out of the statute. But at its core, this case implicates workplace arbitration agreements.
Okay, thank you.
You used up your time, but we'll see. If anybody has if anybody has an additional question, we can sort that out. Ms. Patel. You're muted, Ms. Patel.
Good morning, Your Honors. May it please the Court. Seema Patel on behalf of plaintiffs Ms. Lichon and Ms. Smits. Your Honors, sexual assault is not related to employment, period. At its core, that is the issue that this Court has to consider and decide. Defendant's hyperbolic argument aside, this case does not deal with the end of all arbitration in all contexts. In fact, instead, this case is about the interpretation and application of specific contracts at issue, which by their plain language contain the phrase relative to your employment. Thus, in order to be mandated to mandated arbitration, you have to have a claim that falls relative to your employment. Now, before sexual assault is not related to employment. Before I get into the meat of my argument, I think first we have to discuss what is the paradigm that arbitration contracts are going to be interpreted under. And I think that the answer is that arbitration contracts should be interpreted in the same way that all other contracts are interpreted in Michigan, which is according to the plain terms of the contract. This court unanimously in Altobelli just a few years ago adopted this paradigm. And it said that arbitration contracts are governed by the terms of the language of the contract, and the courts and parties look to the language of the contract to determine A, who is covered by the contract, and B, what is the subject matter covered by the contract. A party can't be forced to arbitrate an issue that they haven't agreed to arbitrate. Now, under that paradigm, the issue before the court is, what does this phrase relative to your employment and this specific employment contract mean? The relevant clause states, this mandatory dispute resolution procedure shall apply to all concerns you have over the application or interpretation of the firm's policies and procedures relative to your employment, including but not limited to, etc. So that critical phrase, that critical clause relative to your employment is a limiting clause. It's a restrictive modifying clause that defines what claims can be subject to mandatory arbitration. And in this case, the only claims that are subject to mandatory arbitration are those that are relative to employment. So then the next step in the analysis is, what does that phrase mean? What does relative to employment mean? And can claims arising out of a sexual assault, are those claims relative to employment? My answer is no. And the first thing the court must look at is the plain language of the contract. You can look at dictionaries to see what would a reasonable person reading this contract interpret the phrase relative to your employment to mean. Under the MVRPA, relative is an adjective, and the contextually appropriate definition says relative as having reference, relevant, pertinent, usually followed by to, the facts relative to the case. Related is defined as associated, connected with. Relate likewise is defined as to bring into or establish connection, to relate events to probable causes, to have reference or relation. So these definitions taken together connote more and require more than just a tangential impact on employment. For something to be related to or relative to employment, there must be some connection, some context and nexus that intrinsically ties the two together. Now, with that in mind, we can interpret and analyze that is there a intrinsic connection and nexus between employment and sexual assault? Well, there isn't. Sexual assault is not a foreseeable consequence or a foreseeable risk of employment. You don't go to work and anticipate that you could be sexually assaulted. That is not within, a reasonable person would not foresee that. Sexual assault has nothing to do with the terms and obligations of employment. For nothing in the job duties or descriptions of a paralegal or a receptionist, nothing in the job descriptions of these duties have anything to do with sexual assault. Like there's nothing to connect sexual assault to these ladies' employment.
Ms. Patel, I'm gonna stop you right there and just let folks get to questions, okay? Starting again with Justice Markman.
Yes, counsel. I certainly share your premise, counsel, that we try to give reasonable meaning to the words of the contract. I'm just having a hard time, though, looking at the way that this case was pled, in which we see in the complaints repeated assertions in almost every count that the defendant, quote, was at all times acting within the course and scope of his employment, that he created a, quote, hostile working environment, and that the firm knew of Morse's conduct and failed to take any remedial action. How, under those circumstances, can we easily conclude that the claims here do not specifically and directly relate to employment?
Well, my answer to that question, Your Honor, is two-part. First, it is the gravamen of a claim that controls, not the labels or procedural labels that an attorney puts on that. So despite how many times we reference employment or employer in our complaint, that doesn't obviate the court's obligation to look into, well, do these claims actually have any relationship to employment? Are they relative to employment? And I mean, that's something that this court has espoused, and as recently as last week in the court's order in Scola versus J.P. Morgan Chase and Company, I think all 7 justices agreed that you look to the gravamen of a complaint to decide, do the claims sound in, what do the claims sound in? Do they sound in that, I think that case it was premises liability versus ordinary negligence. No matter what procedural labels that a attorney puts on to the complaint, it's the gravamen of the complaint that controls. And here, the gravamen of plaintiff's complaint deal with sexual assault. They're not suing for adverse employment, like they're for being terminated or for being demoted, or even a hostile work environment. What they're suing for is to hold their assailant accountable for sexual assault. And that you can see in the request for relief that we've pleaded. All of the damages that are pleaded are traditional tort damages. We're not asking for back pay. We're not asking for reinstatement. We're asking that these ladies be allowed to litigate their claims in open court and be allowed to, because their claims relate to sexual assault and battery, not to their employment at the law.
Counsel, I'm not sure I understand what you mean, what your terminology is when you describe the language that I just quoted from as constituting procedural labels. What does that mean exactly? What is a procedural label in this context? Well, I mean, a lot of the references of employment in the complaint deal with providing background about what happened. Nobody disputes that Morse was these ladies' employer. Nobody disputes that, at least for Ms. Lichon, a lot of the assaults took place at work. With Ms. Smits, the assault took place at a work-related party. That's undisputed. So that's providing justa and background for how these things occurred.
Second, what I mean by saying that that we still have to do an analysis of whether the claims are related to employment and that the gravamen of the claims controls as opposed to procedural labels. Just because I say the claim is related to employment in the complaint doesn't make it so. The court still has to go to the analysis of the plain language of what does related to employment mean. And as I was talking about before, the plain language requires some sort of nexus or connection to employment that's beyond just where the assault took place. And I think the court can also look to its own precedents as well as persuasive authority from other jurisdictions to inform this question. This court's decision in Hamed v. Wayne County is particularly significant because in that case, the court looked at and examined exactly the issue that I want the court to examine here, which is what connection, what nexus does sexual assault have with employment? And in Hamed, the court held that there isn't one. Now, Hamed is a little different because it did deal with vicarious liability, and the issue is whether the county could be held vicariously liable for a deputy's misconduct. The deputy was the assailant. He raped somebody in the Wayne County jail. The plaintiff in that case was saying, well, their argument was, but for the deputy's employment, but for the fact that he was at the jail and he committed the assault while working at the jail, that was enough to bring it within the scope of employment, that there was some connection and nexus to employment. This court held that it wasn't, and the language at issue there was whether something was within the scope of employment. Now, I recognize that within the scope of is not the same thing as related to, but the two still have to be, I think that the two should be interpreted in parallel terms because the court still in Hamed fundamentally looked at what is the connection to sexual assault and employment? What is the connection between sexual assault and what is the nexus between the two? And the court found that there is none. Just because the assault took place at work or was committed by somebody who works there was not enough to create a sufficient nexus and connection to bring it under the scope of employment. Likewise here, just because the assailant is the boss or the assault takes place at work is not enough to create a sufficient nexus and relationship to employment. And it goes back to the terms of the contract. The ladies only agreed to arbitrate claims that are relative to their employment. And when you go into that deeper analysis and look beyond the procedural labels put on the complaint, these claims, sexual assault is not related to employment.
Thank you, counsel. Thank you very much.
Justice Zara?
I'll just follow up on some of the questioning of Justice Markman. In response to his first question, you indicated it's the gravamen of the complaint, not the label that's put on it. Well, I couldn't agree more. Your client, though, you put on the label and then made the allegations. So as I look at the complaint, employment-related allegations are found throughout it. Count one's workplace harassment, okay, that I think clearly falls within the arbitration agreement. Count two, you label it sexual assault and battery. But then when you look to the allegations within that complaint, for example, paragraph 62, Michael Morse as owner and agent of defendant Mike Morse Law Firm. Paragraph 63, Mike Morse to defendant Mike Morse Law Firm's Human Resources. The report was to the Human Resources Department and to her superiors, all within the workplace. Paragraph 68, Mike Morse Law Firm failed to take any remedial action. It all seems to be, by the allegations you drafted, they all seem to be tying back to the employment arena. And again, all the cases you cited, Hamed and the others, those are very different types of scenarios. Here, we're just trying to determine whether these allegations bring it within the scope of the arbitration agreement. How does the gravamen of the complaint help you?
Well, a couple of vectors. First, Your Honor, how the contract is interpreted and whether the sexual assault is related to employment isn't going to be governed by what labels we put on it. It's not going to be governed by the context that we're giving that this happened at work or that it was perpetrated by the boss of the firm. Second, In interpreting the contract, you have to, it matters when you're interpreting the phrase relative to your employment. Now, the cases came about because the crime or the assaults were perpetrated at work, and that is reflected in our allegations in the complaint. But the contract should be interpreted from the viewpoint of when the women entered into the agreement. Now, when they signed the agreement and agreed to arbitrate all claims relative to their employment, would a reasonable person reading that contract think, I'm agreeing to arbitrate claims of sexual assault and battery? And I think the answer to that is no. Also, the second vector, Your Honor, this, as Mr. Riley pointed out, this litigation was at the very inception. We were answering a C7 motion. We could easily amend the complaint to take out all relevance or all reference to employment, and the gravamen of my plaintiff's claims would still remain the same. It doesn't matter that Mr. Morse was the employer. It doesn't matter that that the assault took place at work. The gravamen of these claims is that they were assaulted and they want to hold their assailant accountable for his actions.
Thank you.
Justice Viviano?
No questions. Thank you.
Justice Bernstein?
Counsel, good morning and welcome, and thank you for coming today. I would like, and I think, this is a case that I think does involve a certain degree of public policy. I mean, ultimately, that seemed to be kind of a major focus of the Court of Appeals opinion. And I guess I would just like to ask you, from a public policy perspective, if this court were to allow this case to move forward into arbitration, under the public policy perspective that the Court of Appeals outlined, what concerns would you have for the workplace if we were to overturn the Court of Appeals ruling?
I think that the data is unsurmountable that in the context of sexual assault, mandatory secret arbitration is very bad public policy. I want to take 2 points to answer regarding public policy. The first, we're not advocating necessarily a public policy perspective. It's actually defendants who are bringing public policy into this conversation. Defendants are saying that the arbitration agreement should be interpreted based on this public policy of favoring arbitration. We don't agree that that's the analysis that arbitration contracts should be considered under, but if the court is going to consider that, if the court is going to say, okay, there's this public policy out there for favoring arbitrability in arbitration contracts, then at the same time, we have to address the public policy that arbitration in the context of sexual assault is a very, very bad idea. Mandatory arbitration of sexual assault claims in the workplace undermine and foster a culture of secrecy and abuse. The system perpetuates abuse by silencing victims with nominal payouts and critically shields the abuser from taking responsibility or changing a broken system. It is no coincidence that only after allegations of sexual assault and abuse become public that there is any real reckoning to hold high-placed abusers accountable for their actions. In the wake of the Harvey Weinstein scandal, the code of secrecy that has formerly protected abusers is breaking down. After brave women stepped forward, sometimes at extraordinary personal cost, household names such as Roger Ailes, Bill O'Reilly, Charlie Rose, and Matt Lauer are all being held accountable for their actions. Public disclosure allowed victims of Larry Nassar to hold him accountable for decades of abuse that was previously overlooked and hidden by the powers that be. Despite facing a barrage of personal attacks and undiluted victim shaming, victims of sexual assault are speaking out and demanding that their abusers take responsibility and face meaningful consequences. That is precisely what Ms. Smits and Ms. Lichon are seeking to do here, to hold their assailant responsible in a court of law. Now, public policy is a little different in the context of secret arbitration in the context of sexual assault, because it's not just a policy that the court is upholding. By upholding secret arbitration, the court is in effect becoming complicit in allowing serial sexual abusers to get away with their conduct with impunity. So in essence, the court is turning into an instrumentality for for perpetuating the system of abuse. And I think that Judge Jansen, writing for the majority in the Court of Appeals, recognized that fact. She wrote, the effect of allowing defendants to enforce the MDRPA under the facts of these cases would effectively perpetuate a culture that silences victims of sexual assault and allows abusers to quietly settle these claims behind an arbitrator's closed door. Such a result has no place in Michigan law. And I think that she is absolutely right, because the court has a vested interest in not becoming an instrumentality for hiding and fostering sexual abuse and assault. Bringing allegations out in an open court is the only way to pull back the veil of secrecy that otherwise works to protect abusers. Secret arbitration shields perpetrators and acquiesces to misconduct while the victims suffer in silence. Forcing Ms. Lichon and Ms. Smits to litigate their claims in secret arbitration would only serve to hide and acquiesce to sexual assault. In the words of Judge Jansen, I think such a result has no place in Michigan law.
Counsel, thank you.
Thank you.
Justice Clement,
No questions.
Justice Kavanaugh.
No questions.
Does anybody have any follow-up questions for Mr. Riley? We ate up his time in case anything causes additional questions. We can ask one. Okay, thank you, counsel. The case will be submitted. Thank you both.